He has not quoted how he is going to support the prosecution. So
Yes, my lord. That is the basic essential ingredient to invoke the jurisdiction of the court under section 306. What is his role? What is the role of the other man? What is it that he is going to depose? My lord, what the trial judge, I shall take your lordship, did was, no, I am going to give you pardon, but I shall wait whether you are going to support the case of the prosecution or not. Therefore, I will direct the magistrate to record a statement under 164. I will secure it. I will find out. I will read it. Then I will give you pardon. That is, my lord, if I may say so with utmost respect, my lord, that is not the duty of the presiding judge. Ellide? But the trial, in the earlier order, your lordship did not find this. In the earlier order, what the court would say is, no, sorry, I can't direct the accused to go and make a statement under section 164. The stage has gone. Inquiry has commenced. Trial has commenced. Witnesses are being examined. Charges are framed. In exercise of the powers clothed upon the court under 164 CRPC, the court cannot direct. And even the magistrate becomes functus officio in recording the statement under 164. ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸಿ ಮಾಡಿ ಕೂರಿಸ್ತಾರೆ. ಈ ಲಾಯರ್ನ ಕೂರಿಸ್ಕೊಂಡು 164 ಮಾಡಿದ್ದಾರೆ ಅಂತ ಜಡ್ಜ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಲಾಯರ್ ಕೂತ್ಕೊಂಡು ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಿರೋದು. ಐ ಶಲ್ ಶೋ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ನಾವು.
ಅಲ್ಲ ಎಲ್ಲ ಆಗೋಗಿತ್ತಲ್ಲ, ಇದು 164 ಅಟ್ ಲೇಟರ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹೀಗೆ ಆಗದು.
ಅಲ್ಲಲ್ಲ 164 ನೇ ಲಾಯರ್ ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸ್ಕೊಂಡು ವಿಟ್ನೆಸ್ ಮಾಡಿರೋದು.
ಮುಂಚೆ ತಗೊಂಡ್ರೆ 164 ಯಾರು ಇರಲ್ಲ. ಇದು ಟ್ರಯಲ್ ನಡಿಬೇಕಾದ್ರೆ 164 ತಗೊಂಡ್ರೆ ಲಾಯರ್ ಇದ್ದೇ ಇರ್ತಾರೆ ಪಕ್ಕದಲ್ಲಿ.
In fact, ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸ್ತಾರೆ. Other than the court officers or officials, my lord, whose assistance is needed for the court for the purpose of typing or taking the dictation and all that. ಲಾಯರ್ ಇದ್ದಾರೆ, ತೋರಿಸ್ತೀನಿ. ಅವ್ರ ಲಾಯರು, ಯಾರ ಲಾಯರು? ಅಪ್ಲಿಕೆಂಟ್ ಲಾಯರು, ಅಕ್ಯೂಸ್ ಲಾಯರು. No, my lord, he does not even refer to this order at all, which is bound to. That is what the Supreme Court has said.
No, seeking pardon will not conclude in one stroke. In the sense, today it is rejected. It is not a bar to seek pardon again. It's a different thing. But this should have been referred to.
Referred to, that is number one. Number two, when he seeks for the second time the pardon, it must be the change in circumstance. No, an application next ತೋರಿಸ್ತೀನಿ ನಿಮಗೆ. Then I will take your lordship with the order. My lord,
on the same circumstance, you can't keep seeking.
Can't. My lord, kindly imagine this situation. All the 18 would, there are 17 or 18 accused. One after the other will keep making the applications.
Yes.
No, but kindly go to. The legislature in its wisdom considered it necessary to introduce this section and confine its operation to cases mentioned in section 306 of the court. The object of section 306, therefore, is to allow the pardon in cases where heinous offences are alleged to have been committed by several persons, so that with the aid of the evidence of the person granted pardon, the offense may be brought home to the rest. The basis of the tender of pardon is not the extent of the culpability of the person to whom pardon is granted, but the principle is to prevent the escape of the offenders from punishment in heinous offences for lack of evidence.
There cannot be a recording of 164 statement for the purpose of consideration of pardon.
But here,
no, that's this.
Yes,
that's this.
That is the legal. But here, two things are there. 164 can't be recorded at all. I shall show to your lordship presently. 164 can't be recorded. That is number one.
So the first application was barred. The second application is equally barred. The first order rejecting it is there. The second order accepting it is on the ground that 164 statement gives everything. So according to 164 statement is a nullity.
Yes, it is a nullity.
It should go only on the application.
But the learned trial judge will pass the order solely on the basis of statement that recorded under 164.
That's what I see on page.
I shall take your lordship now.
Page 61 of the order on.
Yes, Lord. The accused has said in his 164 statement, the accused has said in his 164. No.
No, you should only tell me the illegality with recording of 164 statement prior to the grant of pardon. That's all. That's all that's necessary.
May I request your lordship to kindly have a cursory look at 164 for a second now?
If 164 cannot be recorded after the commencement of the trial or at this stage of trial, whether it can be done for the purpose of 306 is what is.
The statute should clothe powers upon him.
Yes, 306.
Whether it is 306 or 161 or whatever it may be, my lord, the magistrate has no jurisdiction to record. the learned sessions judge
Could not
is
have
asking him to
directed-
commit a mistake. He's asking him to commit a blunder by issuing a direction to the magistrate, which he could not have done under the statute. But I shall take your lordship to the provisions of law.
Now, for illustration, if this is permitted, now every court of session during the trial may direct magistrate to record 164 statement and get it.
Well, if the evidence that is which the investigator had collected during the course of the investigation of the crime is certainly insufficient.
According to them, it was sufficient.
My lord,
No, that's what.
8 eyewitnesses in the case. 6 earlier they have been treated hostile. Subsequent to the CBI taking over the investigation, they have examined 2 eyewitnesses. Their statements are there. Their statements under 164 is also there, unless and until they say that from the evidence which we have been able to collect subsequent to the notification issued by the state government is certainly insufficient to make out a case against the accused, then only, my lord, the court can do it. That is what they would say here. The present accused that he would make full and true disclosure of the whole of the circumstances within his knowledge relating to the offense. This court is not aware as to how much information is known to the present accused regarding the commission of the alleged offense and whether he had participated in the larger conspiracy to commit murder of Yogesh Gowda. And if so, who is the key conspirator to commit the offense of murder of Yogesh Gowda? I do not think that the tender of pardon will be in the interest of successful prosecution of the other offenders whose conviction is not easy without the approver's testimony. Kindly underline this, Miller. It will be indubitably agree to tendering of pardon.
Direct magistrate to record 164 statement and get it before.
ಕ್ವಶನ್ ಮಾಡಿದಾಗ ಈ ತಾಪತ್ರ ಆಗುತ್ತೆ ಕ್ವಶನ್ ಮಾಡದೇ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರುತ್ತೆ if it is questioned before your
Yes.
lordship
Yes, sir.
then the problem arises otherwise no but what the law says is first tender pardon and then record statement ಇಲ್ಲಿ putting the cart before the horse
No, after tendering pardon, definitely it is cross
ಅಷ್ಟೇ
examination.
ಅದೇ ಅಷ್ಟೇ ಇರೋದು ಇನ್ನೇನು ಇಲ್ವೇ ಇಲ್ಲ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ
After tendering pardon, he will give examination.
ಅಷ್ಟೇ.
Recording of
ಅದು ಬಿಟ್ಟು
statement.
ಬೇರೆ ಏನು ಮಾಡಕ್ಕಾಗೋದೇ ಇಲ್ಲ But for the purpose of finding out whether he is going to support the case of the prosecution, he can't be directed to go and.
One clarification. Once he's tendered pardon,
Yes.
after tendering pardon, the court-
164 ಇಲ್ಲ.
what is that statement?
That is regular evidence.
It is not 164.
Oh.
So I just
Well,
want to
what
know,
happens is this-
164 is not available after the trial commences in terms of the
He
statute.
becomes a witness for the prosecution.
Yes.
He becomes a witness for the prosecution. No, he dismisses the application on the ground that your application is bald. It does not contain the details that are needed. I can't direct the recording of the statement of the accused under 164. You have not shown or said anything about the role which you have played and the role which the other accused have played so that I could come to a conclusion. That is number 1. Number 2, my lord, he would also dismiss the application on the score that unless and until the prosecution contends, but for his evidence, as an approver, it is difficult for us to make out a case against the accused. That is the law. That is the correct legal position.
So after